again. I'm Sandy Mayson. It is great to be here. It's been a thrill to be in this room with people who have been inspirations for me and my work for a long time. I am a former public defender from New Orleans, where I worked with Anna Van Cleve 15 years ago, and currently I'm a professor at Penn Law School. I teach criminal law, evidence, related things. My scholarship has focused significantly for the last 7 years on bail, pretrial release, and detention. So we've been, thus far today, talking about what is actually happening on the ground, how you actually make the pretrial system rational and just. That's what really matters. But now I'm going to do the academic thing and take a big step back and step up and talk for a little while from the perspective way, way up in the ivory tower, try to just tell you my view of where we are in the story of American bail. So this is pretrial release and detention, a bird's eye view. And the thesis of this talk, which will be informal, and I'm going to leave some time for questions at the end, is that one way to understand the story of American bail is a continuous, ongoing effort that began way, way back in the founding era to make our pretrial law and practice faithful to our foundational commitment to individual liberty and fairness. So first, it seems a fitting place to start with this pronouncement from the conservative former Chief Justice Rehnquist of the United States Court in Salerno, that in our society, liberty is the norm, and detention prior to trial or without trial is the carefully limited exception. This is an aspirational statement. We all know that pretrial detention, especially over the last 30 to 40 years, has not been a carefully limited exception. Just to remind ourselves why we are here, why this matters, I know these are figures you all know, but I think they bear repeating and reminding ourselves. As some of the panelists in the first panel said, our incarceration rates in the United States are astronomical relative to our peers in the developed world. This is the US next to other founding NATO countries. It has Pennsylvania because that's my home, and I use this slide at home. But we are not even in the same league. And of those many, many, many of our people who we incarcerate, pretrial detainees make up a significant portion of the incarcerated population at any given time. So you see on the right, I take these from the Prison Policy Institute, thank you, Initiative, PPI. Local jails constitute approximately a third of the total incarcerated population at any given time. On any day in America, there are about 500,000 people behind bars in local jails. Over the course of a year in recent years, jails have reported approximately 8 million admissions a year. That's lower than it was 10 years ago, but it's still very high. It's a lot of human beings. And it's pretrial detainees that have driven jail growth since the 1980s. Whoops. So the first problem with our system is scale. The second problem is racial disparity. This is just data I pulled from the National Bureau of Justice Statistics, the BJS. It shows racial disparities in cumulative national arrest rates over time since the 80s. And they are improving. They were worse in the 80s and 90s, but they are very stubborn. They just persist. And although the trend here is a positive one, if you look at the data since 2014, those lines have remained parallel. I also, whenever I talk about high level, the big picture stats, I like to remind people that the the problem of racial disparity in the system is not just a problem of enforcement, it's also a problem of under-enforcement. I recommend this book by Jill Leovy. The communities of color, marginalized communities, under-resourced communities that bear the brunt of our excessive incarceration also suffer from under-enforcement, particularly with respect to violent crime. So this is a chart showing homicide clearance rates by victim race for a bunch of decades. And as you can see, so clearance rates, some of you know what that is. In case you don't, this is the rate at which an arrest is made for a homicide. Someone is dead and an arrest is made. Not necessarily of the right person, not a conviction, let alone a conviction of the right person, just there has been a homicide and somebody is arrested. Homicide rates for other demographic groups, yeah, they could be better, but they've been steady or improving since the 70s. Meanwhile, homicide clearance rates for Black people in America have been steadily falling and are fairly abysmal. Right? It's more likely than not that if you shoot a Black person in America, there will not even be an arrest made. Right? So racial disparity, racial inequity is just pervasive in our criminal legal system. And this also, of course, manifests in the pretrial phase. So for the rest of this talk, I'm going to do just a cursory journey with you all through the past, present, and future of American bail. We'll start in the founding era, largely because I just completed a large research project about that. And then we'll talk about major developments in the present, and finally look to the future at opportunities and challenges ahead. So the past. As I say, this is where I've been. I've been immersed in 1790s bail law and practice for the last few years with a co-author, Kellen Funk. And if you really, really want to get into the details of this, you can read our article in the Harvard Law Review, or you can go to the website. I'm going to just give you the main points. So first of all, it's really fun to be a legal historian. This is me with the pretrial the Prisoners for Trial docket from the Walnut Street Jail in Philadelphia, the nation's first penitentiary from 1790 to 1804. If you want to see it yourself, you just go there and ask for it, and they give it to you, which I find terrifying. What we learned from our excursion into the law and practice of bail in the founding era is that it was messy. It was messy then as it is now. And there were really two different laws of bail. There was the bail system, the bail law on the books, and then there was the way that bail operated on the ground for marginalized groups. So first, bail on the books. What is our, what's our legal heritage with respect to bail? When the colonists came to America, they brought with them English legal institutions and the English common law, including the English law of bail. And a lot of American colonies and subsequently a bunch of American states maintained the basic structure of the English law of bail. But some of the colonists who came to this country did not like the English law of bail, particularly people who came as religious dissenters. So people like Nathaniel Ward in Massachusetts and especially William Penn in Pennsylvania. They had been jailed repeatedly in England because of their religious dissent, and they'd been jailed without bail. They felt that to be tremendously unjust and one prominent feature of a tyrannical regime. And so when they created new governments, most notably William Penn with the frame of government in Pennsylvania, they very intentionally wrote a different kind of structure into their state constitutions. So this chart shows you two different models of bail that coexisted in the founding era in the United States. On the left was the model that we inherited from England, which Kellen and I in this piece call the common law model of bail. At common law, a significant proportion of people accused of crime were not bailable at all. They were detained, no discretion to the justices of the peace who made custody decisions. That's the red piece there, not eligible for bail. Then there was a tiny sliver of accused people who had a right to bail. That's the green sliver at the bottom, people accused of very petty offenses. Most people were bailable, but the magistrates who made bail decisions had discretion whether to bail them or not. That's the yellow chunk in the middle. William Penn eliminated the slice of people who were not bailable, for whom detention was mandatory, and enlarged the group of people who had a right to bail, right, leaving only a small sliver of discretion to the judges for those charged with the most serious offenses. In Pennsylvania at the time, the Quakers made intentional homicide the only capital offense, and so people charged with first-degree intentional homicide were the only people who, in fact, could be detained without bail. The idea behind the provision, which later became the consensus text for the new states and was adopted into many state constitutions, including yours. This is the provision that all prisoners have the right to be bailable by sufficient sureties, except in capital cases where the proof is evident and presumption great. Okay. The idea was that pretrial liberty is precious and should not be abridged without the judgment of a jury of one's peers, directly from Magna Carta. So Penn enshrined this in the Pennsylvania Constitution. The other states, many of the original states in the Union picked it up, and then as new states joined the Union, they too adopted it without a whole lot of thought or deliberation. It seems admirable and laudable, and it is comforting to learn that the founding generation prized pretrial liberty in a way that many of us did. But that was bail on the books. So how did bail actually operate on the ground? What we discovered in the course of this project is that it depended who you were. So Aaron Burr turned out to be a very illuminating case study. Aaron Burr, who you probably mostly all know through Hamilton, the musical, was arrested and charged with treason against the United States for his ambiguously attempted secession plot. And in the course of his federal prosecution, he was released on bail 5 separate times. Now, take a step back here and note that in the founding era, bail did not refer to a cash deposit. Okay, bail was a process of release. As I know many of the pretrial experts in the room already know, bail meant transfer from the custody of the state to the friendly custody of your family or your employer or your acquaintances who pledged that you would return to court and promised to forfeit a specified sum if you didn't. Okay, so bail meant essentially an unsecured bond, right, signed by somebody, and then you typically had to sign an unsecured bond yourself. No cash anywhere in the system. So Aaron Burr, he is released on bail 5 separate times. He pledges a whole ton of money. His acquaintances pledge a whole bunch of money too. He continually jumped bail and disappeared, fled one jurisdiction, fled another. Nothing ever happened to him. Ultimately, he wound up in Paris, and the federal government gave up the case because it was too embarrassing at that point. For Aaron Burr, the system did protect his liberty. This is the last bond written by John Marshall, Chief Judge Marshall. But it did not work quite so well for other people. The second aspect of this research project was we spent a lot of time combing original court and jail records in Philadelphia, which maintains such records. So this is a list of original jail and court books and dockets that we transcribed, scanned and transcribed, and they're all available on the website if you're a history buff. This was a daybook of a local justice of the peace, the equivalent of one of our own local magistrates who made custody decisions. People who were charged with a crime were brought to this magistrate, Ebenezer Ferguson, and he heard the charges and then decided whether to commit them to jail or to release them via bail. Now, this was interesting because technically none of these people were detainable. Almost every single one of them had a right to bail. And my co-author and I sort of hoped when we began this project to find that in the founding generation, no one went to jail pre-trial because the law said you couldn't. Right? We prized pre-trial liberty and everybody stayed out and it all worked fine. And that's not what we discovered. Justice of the Peace Ebenezer Ferguson committed approximately half of the people who came before him to the local jail. The people he committed were people of color. They were women, women of ill repute. They were people who were quite seriously struggling with substance addiction, alcohol generally. They were people who were regularly committing petty thefts and other petty offenses. Those people went to jail. For some people, the system worked as intended. This is an example of an entry for an accused person named Rachel Wallace. So I've transcribed it for you, because otherwise it's indecipherable. Commonwealth versus Rachel Wallace. She was charged on oath by Ruth Craig with abusing and threatening her so that she's in personal fear of her. A couple things of note about this entry. First of all, everyone involved in a criminal case at the founding was bailed, not just the defendant. So the defendant, Rachel Wallace, she is bailed. She's bound in 20 pounds for her good behavior. Her surety, who appears to be her sister, Rebecca Wallace, is also bound. She also pledged to forfeit 20 pounds if Rachel Wallace didn't maintain good behavior or come to court. But the accuser, Ruth Craig, she too was bound. She was bound to prosecute, as accusers always were, and witnesses were bound to give evidence. Everyone was bound. This was the mechanism of ensuring, or at least encouraging, the participants in the case to show up to court so that the case could proceed. Another thing of note about this entry is despite the fact that Rachel was bailed, there's also the denotation committed. And a lot of entries have this kind of double notation. Our supposition is that this magistrate would commit people who didn't have sureties, people who would vouch for them. That's one way people went to jail. You didn't have sureties. And then if a surety shows up, then the person gets out. We looked at bond amounts by party, and as you can see, there were kind of regular amounts by party, but the main point here is just that bail was not a criminal defendant thing, it was an everybody thing. This is the prisoners for trial docket. And over time, in this period, this very early founding period, we saw rates of detention for those who didn't have sureties, who the magistrate wasn't even permitting to produce sureties, go up and up. The other thing that was weird about this founding era pretrial detention is that being charged with a criminal offense was not the only way you could find yourself into the local jail. Far from it. People were also routinely committed as vagrants and vagabonds. There was a whole parallel civil commitment system that was the vagrancy docket. You could be committed to the almshouse if you didn't have money. And then you could also be summarily convicted by the magistrate for petty offenses. The magistrates just had summary conviction power. So there's this entire group of the population that is going to jail whether because they're being detained pre-trial on a criminal charge and the magistrate thinks they don't have sureties, because they're being criminally convicted on the summary jurisdiction of the magistrate for a petty offense, or because they're being committed on the basis of some amorphous civil criminal authority as vagrants. It's really not what we hoped to discover. Also note that the racial disparities were extremely evident even then in the group of people being committed to jail. There's a very small population of color in Philadelphia at the time, and a vastly disproportionate number of that population were in and out of jail pursuant to the vagrancy docket or the pretrial docket. We learned a couple of things from this exercise, which were not the things we had hoped to learn. We did affirm something that has been a principle that's been a common principle in the literature and in the bail discourse, but we wanted to establish conclusively on the basis of historical evidence, and that's that there was no cash in the system in the founding era. It was a system of unsecured pledges. It operated on the basis of a reputational economy. Just no cash at all. So to the extent that the bail bond industry has been writing in their amicus briefs to federal courts that cash bail is a timeless American tradition, right, that is just false. On the other hand, it is not the case that from the earliest days of our nation, the law has prized and protected pretrial liberty for everyone. It has prized and protected pretrial liberty in theory, on the books, and in practice for respectable citizens with adequate social capital. It has just continuously channeled people who belong to marginalized communities or who live in precarious circumstances in and out of jails and related institutions. We also learned that there are no easy answers from this history for enduring questions of constitutional interpretation that have plagued and will continue to plague us legal advocates arguing in court. So that was extremely brief, but I want to move on. If you would like to examine some of the historical sources in more detail, you can go to this website, and everything should be there. All right, more recently, the more recent history, I am hoping that you all have some familiarity with. In the 20th century, there have been 3 waves of bail reform. In the 1960s, people began to appreciate that we had come to rely on cash bail as the arbiter of pretrial release or detention. That seemed bad, that seemed unjust. There was a lot of organizing, there was agitation, there was legal reform. It culminated in the Bail Reform Act of 1966. Subsequent to that, release rates pretrial did begin to increase quite dramatically nationally and in specific jurisdictions. But concomitantly, there began a dramatic increase in crime, which was not just national, it was global. But the law and order politics of the late 1960s, 1970s, in combination with the actual increase in crime, drove the second wave of reform in the 1980s, which was dedicated to ensuring that truly dangerous people would remain detained in the pretrial phase. So 1984 is when the Federal Bail Reform Act is amended to include preventive detention provisions, and a lot of states copied it, created their own preventive detention structures for the first time. Nearly all of them, though, maintained money in the system. And the problem with setting up a preventive detention regime without eliminating money as an option or making it difficult to use is that you can always just use money instead to detain or to try to detain the people you think should be locked up. And so that is what has happened in states like Wisconsin that created a preventive detention regime in the 80s but kept money in the system. It just becomes a dead letter. No one uses it. They use money as a proxy for a detention order, with all of the flaws that entails. That brings us to the third and ongoing wave of bail reform, which began circa 2015. You all remember Khalif Browder, Sandra Bland, this incredible growth and awareness of the costs and injustice in the use of money bail to the extent that we've been using it. And of course, the goal of this wave broadly is to shift away from money as the arbiter toward a transparent in or out model. You've heard a lot about what's happened in Illinois, which is incredible, and you know more than me about what's happening in Connecticut. I've just turned off, there we go. Turned off my slides. Okay, so I will highlight a couple of the major developments, and then I'm going to talk a bit about what some of the social science evidence has been that has informed and can continue to inform pretrial change. Connecticut, you guys are teaching me. There has been statewide comprehensive or statutory reform in New Jersey, as you know, New Mexico, with leadership from the New Mexico Supreme Court. I put New York up here in parentheses because, is there anyone from New York in here? Anyone involved in? All right, New York was a disaster. New York is a cautionary tale. Do not do bail reform like New York. It is such a tragedy for all of us that what happened in New York has become emblematic of bail reform, what people think that it is and what people think its consequences will be. New York bail reform involved a bunch of legislative horse trading and staffers inserting poorly thought out provisions into the budget law at like 2 in the morning, and it just, don't do New York. And then Illinois, which seems to me to be very clearly a qualitative step forward in our collective national effort to rationalize our bail system. There's been litigation, civil rights cases challenging aspects of money bail systems throughout the country. Some of the big decisions have been the O'Donnell case in the Fifth Circuit, Humphrey from the California Supreme Court, Valdez-Jimenez in Nevada. And there have been judicial setbacks, decisions that are going to be significant roadblocks to reform via at least federal litigation in the courts. So Davis in the Fifth Circuit, Walker in the 11th Circuit, then Schultz in the 11th Circuit. These federal courts have interpreted various procedural doctrines as foreclosing some of the most promising avenues of challenging aspects of money bail systems via federal constitutional law. So the future of bail litigation in the federal courts, I think right now, is very much up in the air. There have been state Supreme Courts that have promoted bail reform through court rules, notably in New Mexico. I'm hoping in Pennsylvania, a work in progress, stay tuned. And then, perhaps most significantly, there's been local action all over the country in jurisdictions in every single state, counties, cities, coalitions. That has been the thing that has driven the most significant change, and I think it will have to be the thing that continues to drive change, if it does. There's also been some helpful social science. The recent quantitative scholarship has, I'm hesitant to speak in too glowing terms about this because I've been involved, but it's really not me. I'm just a lawyer. I like to co-author with people who are economists, so it's really them. They have produced a new generation of data and data analysis that is far more sophisticated and advanced than we've ever had before. So in 3 ways in particular. First, we have big data now. We have giant data sets that include hundreds of thousands of cases. They enable sophisticated statistical analysis in a way that we never could before. We can do regression analysis controlling for far more variables than we ever could before. The best research also uses either actual experiments, randomized controlled trials, or natural experiments. This is the gold standard for doing social science. A randomized controlled trial, you can do causal inference about what causes what because you take 2 groups that are statistically identical and they're only randomly separated into 2 groups. And if you have an intervention for one group and not the other, and then you have different results, you know the intervention caused the result because everything else about the 2 groups is the same. And so that's the gold standard. But if you can't do an RCT, you try to do a natural experiment where you look for some naturally occurring phenomenon that produces 2 groups of people who are statistically identical except for one random feature. And then you look at the differences in outcomes between these 2 groups, and you can do causal inference. I'll explain with an example in just a minute so you know what I'm talking about. All right, the new research has also evaluated not just the outcomes of pretrial detention on, or rather not just the effects of pretrial detention on case outcomes, but also longer-term downstream effects. So what have we learned? First, we've learned that pretrial detention causally distorts case outcomes and sentences. So it's not, we had plenty of research looking at the group of defendants detained pretrial and the group of defendants released pretrial, and you could look at the outcomes of both groups and see, okay, the outcomes of the detained groups are worse. They're convicted more, their sentences are longer. But the problem is, there's a reason people are detained. I mean, sometimes it's arbitrary, but as a whole, they're probably charged with more serious offenses. They probably have longer criminal records. Maybe the facts in the case are worse. So you can't tell if it's the detention itself that's causing the difference in outcomes. With a natural experiment, you can. These stats come from a paper I happen to be involved in about Harris County, Texas, Houston, Texas. This paper actually came to figure in the O'Donnell litigation in the Fifth Circuit. And our natural experiment was, turns out, misdemeanor defendants arrested closer to Friday, payday, were much more likely to be released than misdemeanor defendants arrested farther away from payday. You know, we speculate that's because if you're arrested close to payday, then your family members get their money and they can come bail you out. Otherwise, the groups of defendants arrested close to payday and farther away from payday were statistically identical. Right? Same charge breakdown, same criminal history breakdown, anything else, same. You look at like the gender, the age, the demographics, socioeconomics, identical across these 2 groups. But the detention rates were different. And lo and behold, of these identical groups, the group detained more had far worse outcomes. They were convicted much more frequently, their sentences were longer. So that gives you a pretty robust basis to infer it's the detention that's causing those bad outcomes. That's just one example of a natural experiment. Not news to anyone who's ever worked in the system, but it's nice to have the actual quantitative verification. Another paper by Dobby, Golden, and Yang, using the same kind of methodology, demonstrates that detention actually produces adverse employment consequences, reduces average earnings, and reduces the amount that people are able to obtain via the earned income tax credit. So it has downstream economic consequences. We had suggestive evidence in our data, not conclusive, but suggestive evidence that detention actually causally increases future crime, even serious crime like felonies. Again, quite intuitive, but nice to see it in the data. As to racial disparities, I started with racial disparities. I want to circle back. Racial disparities are pervasive in the pretrial system. This is just happens to be some data that we pulled from Pennsylvania. So across my state, Pennsylvania, this represents the share of white defendants who receive cash bail. And you can see a lot of people don't, right? It's a relatively low percentage throughout most of the state. Excuse me. This represents the proportion of black defendants who receive cash bail, a lot more. And this shows the gap in the likelihood of being assessed cash bail between white and black defendants. So the redder the state, the higher the ratio. The redder the county, rather. In Somerset County, black defendants are twice as likely as white defendants to be assessed cash bail, and we all know that cash bail translates into high rates of detention. If you look at the detention statistics, black people in Philly, my town, make up 44% of the population, 59% of criminal defendants, and 66% of defendants detained pretrial. Even when we reduce detention rates, the racial disparities persist. Right, this is all to say that those damaging effects of pretrial detention that we just canvassed, that are now fairly clearly established by the data, right, disproportionately affect black people and black communities. So what to do? Y'all are working on the institutional change, the cultural change, the state constitutional change. Here are some things that the evidence suggests can be effective. First, just taking cases out of the system. One way to do that is reduce arrest rates. Shift to citations if you can for more low-level offenses. Another way to do that can be through diversion programs. There is a great recent paper from Suffolk County using similarly rigorous quantitative methods, finding that those misdemeanor arrestees whose cases were simply dropped, there was a causal effect on their future entanglement with the criminal system. Now, I'll say one possible interpretation is they committed less future crime. The other interpretation is without the mark of a misdemeanor conviction on their record, they were less likely to be subsequently arrested and prosecuted. And we can't tease those apart.
Could you explain that a little bit more?
Just what I said about the two interpretations? Yeah, so what we can see in the data is people whose cases were dropped, with the experimental methodology, so you're controlling for all other factors, less likely to be arrested again in the future. Does that mean they're committing fewer future crimes? Maybe. It also might be an artifact of police behavior, system behavior. That if someone gets stopped for potential low-level crime or actual low-level crime, maybe that person has a clean record, police give them a warning, that person already has a misdemeanor conviction, maybe then that person gets arrested and taken in. So that's impossible to disentangle in the data. I want to stop talking so you guys can have just a few minutes to ask questions, but the other things supported by the data: reduce reliance on cash bail. Harris County, O'Donnell resulted in a massive injunction that halted the operation of the money bail system for misdemeanor cases. And there was a lot of fear about that increasing crime, much as there was in New York, and that is not what has happened. This chart shows first just what happened to release rates for misdemeanor defendants when the injunction went into effect. That dotted line represents the injunction. So you can see release rates jumped for misdemeanors. Nothing happened to felonies. The blue dots on the bottom are the felonies. Nothing happened to felonies. As to the overall 3-year recidivism rate, both misdemeanor and felonies stayed pretty constant. The felony recidivism rate, if anything, increased a little bit while the misdemeanor stayed flat, which demonstrates that this change, the jump in release rates, did not cause a jump in recidivism rates. And we know that it's not attributable to other factors because we can compare to the felony offenses. Here's some stats. Things went A-OK in Harris County. In Philadelphia, DA Larry Krasner implemented a bail reform. When he came into office, he had his DAs cease asking for cash bail on 26 low-level offenses. There was an immediate increase on people released on their own recognizance, and nothing happened to failures to appear. Maybe there was a tiny, tiny momentary blip, but nothing happened overall. Nothing happened to rearrest rates. There's some new research that I've left out about the effects of empowering public defenders immediately upon arrest and to be present at the bail hearings. And the early evidence suggests that people wind up doing better in the pretrial phase. There are fewer violations, there are fewer revocations, case outcomes are somewhat better. It doesn't necessarily affect the release rates, but it seems to affect outcomes across the board. And lastly, if we're worried about FTAs, help people get to court. I think we are increasingly appreciating that most people who FTA have not fled to the Bahamas. It's just hard to get to court. It's hard to leave your kids. It's hard to get time off work. You don't know when to. The people who are arrested typically don't have the best calendar management skills. So things like text message reminders can be incredibly helpful. And this is a 2023 study that used a randomized controlled experiment, right, to test the causal effect of text message reminders and found significant reductions in FTA rates. Sorry, guys. There are a lot of opportunities and challenges ahead. I don't have time to talk through what I think some of the hardest questions are. If I can take 5 minutes, I'd love to hear a question or two for you, but I leave that to the organizers. All right, no one's stopping me, so.
I have a question regarding your statistical analyses. What was the time frame you actually analyzed? Was it more than a year? And what was the number of cases that you included in each group? And then the last thing is, when there's a reduction in crimes or whatever it was, did you actually run significance tests? Because sometimes there's a reduction, but it's not. Yeah.
The one I can speak to in detail is, is the Harris County study. Yeah. The time period was 2008 to 2013, so whatever, 7-year period, some time ago, but as of 2017, the system was still operating in the same way. We just didn't have fully current data where we could look at effects and new crimes several years out. The total number of cases in the data set was something like 350,000. What was the last part of the question? The new crimes, we looked at least a year and a half out. And to my memory, again, I am not the statistician, but to my memory, this result of 4 new felonies per 100 at this point in time was statistically significant. But this result was a result of a very complex regression and not the natural experiment. So we were a little more cagey with the language in the study because we don't think it's conclusive. Okay, thank you so much for your time. It's an honor to be here.